Trademarks and the trademark registration process can be complicated. It can be really complicated, in fact, sometimes, but it doesn't always have to be that way. And because I am here to help you, I'm coming at you today with 7 tips to simplify and make the trademark registration process as easy as it can be. Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado. Welcome back to All Up in Your Business. Before we get into my 7 tips to simplify the trademark registration process, keep in mind that while I am a lawyer, I am not your lawyer. The stuff I talk about in this video is not a substitute for actual legal advice. If you need help with any legal situation, you should consult with a lawyer. All right, so tip number 1 to simplify the trademark registration process. I think this should be pretty obvious and not too surprising to all of you. Work with a trademark lawyer, of course. Taking advantage of a trademark lawyer's expertise is going to help navigate this complex process and increase your chances of getting your trademark successfully registered. Trademark lawyers are familiar with the process. We've done it before. We know how it works. The process can be pretty tricky if you're not familiar with it, so us trademark lawyers are here to help you navigate it. Filling out the application correctly is really important. Trademark lawyers know what needs to be in the application, and we know how to avoid mistakes that could potentially hold up your application or prevent it from getting registered. If any issues come up with the trademark application, which is pretty common, we're going to be able to advise you on it and help you get through those issues. And since we know what we're doing, at least assuming you are working with an experienced trademark lawyer, we're going to be able to do it more efficiently and get things done generally quicker than you might be able to do yourself. And of course, working with a trademark lawyer is going to give you some peace of mind that you have someone who knows what they're doing working on this application for you. It's going to save you time, so you don't have to worry about it. Let us handle it. Come here, little bird. All right, little bird's joining us for a little while at least. So if at all possible, whenever possible, consider working with a trademark lawyer. Oh, a little extra tip. Let's call this tip number 1A. If you can't work with a lawyer, I've got a guide that might help you through some of this process as well. It's a free guide that goes into a lot of detail about trademarks and the trademark application and registration process. You can download that for free by visiting the link down in the description. Tip number 2, conduct a thorough trademark search, a clearance search before you start on the application. You want to make sure your desired trademark is available, that it hasn't already been registered, that it's not already taken by someone else, and it's going to make sure you aren't wasting time and money on a trademark that you won't be able to get. This is going to be another area where it will be beneficial to have a trademark lawyer helping you with it. We often have other tools and resources available to us to do these thorough clearance searches. We also know how to analyze the search results, what exactly to look for, and how to identify any risks that might be associated with the trademark application or your desired trademark. If you can't have a trademark lawyer do it for you though, then a simple Google or internet search is a good first place to start. Using the USPTO's search database is helpful as well, although it can be kind of tricky and there are some bugs with it. It doesn't always work out. There's also a free website available called trademarkclear.com that can be helpful with doing some preliminary searching as well. Tip number 3, research and figure out what your appropriate goods and or services are going to be ahead of time before you start working on the trademark application. In case you're not aware, on the trademark application, we have to identify the goods and or services that you are using the trademark with. And we need to be pretty specific and clear with those descriptions. There is an option. We have the ability to enter our own descriptions into the goods and services, but there's also a database of pre-formatted, pre-existing goods and services descriptions that we can choose from. And usually, especially if you are doing this yourself without a lawyer, it's going to be easier to use those pre-existing descriptions. So before you start working on the application, go to the Trademark ID manual. That Trademark ID manual is available at tmidm trademark.uspto.gov, and then you can start typing in some general descriptions of the goods or the services that you're selling with your trademark, and then find the appropriate descriptions that you're going to want to use. That way, when you start on the application, you're fully prepared. You don't have to spend a bunch of time figuring out which goods and services you need to put on the application. Tip number 4, this is a big one. I hope it's obvious, but sometimes it's not. Do not lie on the application. This is particularly important when it comes to your dates of first use of the trademark. We have to indicate on the trademark application the dates when we first started using the trademark in commerce. A lot of people are generally inclined to maybe estimate a slightly earlier date of use. That's bad. If anything, if you're going to not have an exact date of first use, like if you don't know your exact date of first use, estimate later than it might possibly be. If you estimate earlier, if you put a date that is not correct, it can be very damaging. This also goes to if you are applying on a current use basis, but you're not actually using the trademark in commerce yet. This also goes to the specimen. We have to provide a specimen showing how we're using the trademark in commerce. Some people try to create a fake specimen to, make it look like they're using the trademark in commerce. The USPTO, sometimes the examining attorneys on the applications, they can tell when a specimen is fake. Sometimes it's obvious and they'll reject it because of that. But they're not going to really thoroughly investigate. But if the trademark registration is ever challenged, you're going to have to be able to prove that, the specimen was real and your dates of first use were real. So just don't lie. Don't lie on the applications. Don't put false information. That's it. Just don't lie. Be truthful and accurate. Tip number 5 is kind of related to this. Keep records of your use of the trademark. Document when and how you use your trademark in connection with the goods and services on the application. If you're wondering, what does that mean, using the trademark, use in commerce? There's not really a clear, easy answer to it. There's a lot of nuance and stuff into use of a trademark in commerce. The easiest way to put it is with goods. If you're selling goods or products, the date when you first sold your product, first sold your good in the ordinary course of business, an actual sale. So not like selling it to yourself, not selling it to, your cousin at a discount or something. Actual use, actual sales to customers of your goods with the trademark being used with those goods. With services, generally the same idea, when you first provided that service to a client or a customer. And make sure you have documents, records to back up that date of first use. The thing is, the USPTO and the examining attorney, for the most part, they are taking our word for what we're putting in the application. They are assuming we are being truthful and honest and the information we're giving them is correct. They do a little bit of investigating, but not a ton. If we give them a date of first use and an acceptable specimen, they are going to believe us. But if someone else, a third party, ever tries to oppose or challenge your trademark, you're gonna need to be able to prove that that date of first use that you put on your application is correct. You're gonna need to be able to show, receipts, sales documentation, maybe contracts, invoices with clients or customers. You're going to need to be able to prove that what you put on the application was true. If you can't prove that, or if you can't prove your date of first use or the extent of your usage of the trademark, it's really going to damage your rights. It could potentially invalidate your registration as well. So like I said, dated receipts, advertisements of your services that are dated, sales records, really anything that can help you prove and show your trademark in action. Tip number 6, respond promptly to any correspondence from the USPTO. Failing to meet a deadline or provide the information that's requested can damage your trademark application, could cause it to be rejected or abandoned, basically. This often comes up with office actions. The examining attorney on your application might issue an office action setting forth whatever the issues are. Sometimes it's a likelihood of confusion. Sometimes they need clarity on your goods and services. Sometimes it's a specimen issue. With those office actions, currently right now, we have to respond to those within 3 months of the date of the office action. We can request an extension to push that out to 6 months. Either way, we have to respond within that time frame. So if you get an office action or any kind of correspondence from the USPTO, make sure you make a note of that response deadline and provide whatever information is needed. And tip number 7, this is a really big one. It kind of goes along with tip number 6, but it's don't fall for scams. Trademark scams are becoming very, very common, especially with pro se applicants who don't have attorneys on record, attorneys helping them with the application. These scammers, they look at the USPTO database, they can find your contact information, they will often call pretending to be from the USPTO, they can fake the phone number that they're calling from. So if you look up that phone number, it actually looks like it's a USPTO phone number. It is a USPTO phone number. So by all accounts, it looks like they're actually someone calling from the USPTO, or they'll email you about it or sometimes send something in the mail. And what they're trying to do is get personal information from you or get money from you, trick you into believing that they're from the USPTO so they can collect information from you or steal your money. The USPTO will never ask, I say never, never, never ask for money over the phone. They also will never ask for it over email. They might issue an office action saying that you have to pay some kind of a fee, but that payment will go through the USPTO's payment website gateway. They aren't going to ask for that information over the phone. They're also never going to ask for any personally identifying information over the phone either. They're not going to ask you to mail in a payment. So be very cautious and be very on alert if you receive any kind of communication from anyone purporting to be from the USPTO. If you're ever worried or unsure about a communication that you're receiving, go to uspto.gov, find a phone number from them for the trademark office and talk to somebody. Make sure you call them, talk to somebody and verify, is this communication, is this phone call that I got, is it legit? It's probably not. There you go. That's all for this episode, folks. If you learned a thing or two, go ahead and give me a thumbs up. If you haven't subscribed already, please go ahead and do so now. Click that little bell so you get notified anytime I post a new video. And check the description for links to additional information and resources. I gave you a few tips in this video. I've got another video where I talk about some common mistakes that I see a lot of people make with their trademark applications. If you want to check that out, you can click right here and do that. I will meet you over there. Thank you so much for watching. I'm Aiden Durham, and I'll see you next time.